All right, hello everyone. I hope everybody is doing great. Today we're going to cover Chapter 6, Police and the Rule of Law. So, being mindful that when we're speaking about our criminal justice system, the three components, law enforcement, uh, courts, and corrections. But the interesting thing about the police is that the police have to follow the rules. Now, where are the rules? Where do they come from? Those rules come from our Constitution. They come from case law. They come from judges interpreting what the Constitution means. So, when you are a police officer, you're bound by all of these rulings. So, for law enforcement officers, I always indicate to them, don't think just because you graduate out of the academy that you're done with your training. You have to really always have an eye on legal decisions, what's known as jurisprudence. Miranda versus Arizona. That's a decision by the United States Supreme Court that if you are a police officer, you got to do certain things if you want to get a statement from somebody, if you want to admit that statement as part of your case. So let's take a look at the PowerPoints here. The rule of law, the fundamental principle of the criminal justice system. So when we talk about our criminal justice system, we're speaking about the fact that we have written law, we have common law, we have statutes, we have case law. All of these things come together and they are the basis of the judicial decisions. So, this particular belief is that all government officers pledge to uphold and follow the Constitution. When I became an assistant prosecutor, the first day, I had to put my hand on a Bible and take an oath. I had to swear to support the Constitution of the United States and of the state of New Jersey. And it's an oath that you have to take very seriously. As a government worker, you're not working for a private industry. You're not working for, a conglomerate. You're working for the government, for the people. So you have an oath to those people to make sure that you are serving them according to the law with, high ethics. I think that is a very important aspect of government work. Law enforcement must follow the rule of law to maintain legitimacy and trust. When officers and agencies do not follow the rule of law, that's when they lose the respect of the community. That's when they lose the community support. So I always lecture at various departments and I say, if you want to build those bridges back with the community, it starts with the officers' actions within that community. Are they following the law? Or are they using excessive force? Are they corrupt? So when we look at breaches of this rule of law, that's when the legitimacy of those officers, and when it grows, the entire department comes into question. Law and order and justice. So in the early 1900s, the Supreme Court of the United States began to establish rules concerning individual freedoms guaranteed by the Constitution. The Constitution existed from 1789, but the court never really addressed what the rules were. So it was up to the police agencies to kind of follow the Constitution according to what they thought the written word of the Constitution was. Well, the Supreme Court comes in and says, we're not going to trust you. We want this to be followed, and we're going to have these procedural safeguards. These are done as a buffer between the government and the citizen. So in Weeks in 1914, the court unanimously ruled that repeated warrantless searches, so searches by the police without a search warrant, without that document, authorizing them to enter into a home, into a vehicle, into a business, into a safety deposit box, whatever it may be. So this is the police acting on their own, looking at the Constitution, saying, "Yeah, we're on solid grounds. We don't have to go through the warrant process." Well, how do they know they're on solid grounds? Right? They're motivated to get into that account or that home or whatever it may be. What this did was it looked at these warrantless searches at Weeks' home and the seizure of private possessions, and they said, look, this violates the Fourth Amendment. The language of the Fourth Amendment is pretty strong. Unreasonable searches and seizures are against the Fourth Amendment. So, what is unreasonable? Why should it be in the eyes of the police? We need judges here to interpret the facts and circumstances, to give us guidance, to give us procedures, to give us rules. This set the precedent for future court decisions by ruling that a warrantless seizure of property from a private home violates the Fourth Amendment. It is an unreasonable search. So if the cops want to get into a home, either they need a warrant or an exception to the warrant. And there's very few limited exceptions that must have, the facts necessary for that exception. Due process. What is the amount of due process? What are the rights? These are rules that are designed to protect private rights with the Fifth and 14th Amendment Due Process Clause. The Fifth Amendment guarantees federal due process. It's the same amendment that talks about the right and privilege to remain silent. Right? It's the same amendment that was at the center of the Miranda decision. The 14th Amendment says, hey, those federal rights are so important, we're going to force the states to honor them too. So the 14th Amendment brings the due process to the states. And it says basically, here, the federal United States Constitution creates the baseline of protection, the minimum that must be guaranteed. However, the states can give more protection. So in many cases, that is true. New Jersey, New York give more protection to their citizens than the federal U.S. Constitution. Procedural due process is applicable to arrest and trial procedures. This places limits on police power. The idea that the Constitution is there to be that buffer, to protect against the king and the queen. We didn't want another king or queen, so we created a Constitution. Here, this guarantees against double jeopardy, being tried twice for the same offense after being acquitted. Ensures proper arrest procedures. Do they have probable cause? The right to remain silent, right? The cornerstone of the Miranda decision. The right not to be subject to unreasonable searches and seizures. That would be the Fourth Amendment. The right to an attorney, the Sixth Amendment. All of these protections. Constitution means nothing without this in place. So the courts are starting to say, hey, we have this great document, let's breathe some life into it. Right? Let's tell everyone, not only society, not only law enforcement, not only the government, but the people. Let's tell the citizens what their rights and protections are. Probable cause. This is a relatively low standard, but it's an important one. So this standard of proof allows police to do two critical things: arrest a person or apply for a search warrant. It's the same level of proof, probable cause. This is a very, very important finding that is made to kind of get this process going. And it's something that I think is a very vital part of what law enforcement must do. Due process rights related to search and seizure are based on a body of rulings. The focus on arrests, warrants, and searches, and addresses many important interrelated things. So here, that probable cause. Did the police meet this level of proof? Reasonable suspicion. This is actually lower than probable cause. So that probable cause is here. Reasonable suspicion is just under it. Just under it. But it allows something which is known as a stop and frisk, right? So important. We hear it day in and day out here in New York. This is similar to probable cause, but based on a minimal or very, very little evidence. So Terry versus Ohio, that's the case. The United States Supreme Court in 1968 said police officers may not necessarily have probable cause, but if they have a reasonable suspicion that somebody is armed and dangerous, they may pat that person down, limited on their outer clothing, to search for a weapon. So that pat down is found by the Supreme Court in 68. 50 years later, here in New York, it was being used by multiple mayors and police commissioners to try to reduce the amount of guns on the street. Some people argue that it's effective. Some others argue that it violates the United States Constitution. Sybren versus New York, 68 once again. Mere observation of Sybren without hearing any conversations with addicts failed to provide probable cause for a warrantless search. That was about drugs. Most of the warrantless searches that we're talking about, most of the pat downs are only going to be found in situations where there is some compelling danger that's out there. Peters versus New York, 68, officer gave chase to the suspect after observing him sneaking around an apartment building. The officer patted down the suspect and found burglary tools, usually a screwdriver, what's known as a Slim Jim to beat a lock out, a lock punch, all of these tools of the trade that burglars use to breach into residence. And the court upheld the legality of the stop and frisk. And they said the officer had enough. They saw this guy sneaking around an apartment building suspiciously. And yeah, it's not probable cause, but certainly it's a reasonable suspicion. Adams versus Williams, stop and frisk in 1972. Here, this ruled a reasonable cause for a stop and frisk may be based on information supplied by another person, and in this case, a police informant. So, the police don't necessarily have to generate that information themselves. They can be provided with that information from a multitude of sources. Confidential informant being one of them. Sometimes you have citizen informants, just people in the public who want to help out law enforcement. So it really becomes a review of where that information is deriving from. Did that person have the knowledge necessary to deliver this information to the police? Alabama versus White, 1995. The court decided an anonymous tip to police provided reasonable suspicion for a Terry stop. Some states say, well, anonymous tips should be scrutinized because we don't know where they're coming from. So in some jurisdictions, they really treat the anonymous tip in a very negative light. Florida versus JL in 2000. This was a firearms exception to Terry versus Ohio. So in this particular case, the courts refused to recognize an exception, what's known as a firearms exception, because such a ruling could promote false anonymous tips to law enforcement and promote harassment of innocent people. It also could result in less guns on the street, which I think is something that we all want, right? Guns are dangerous. The question is, though, how do the police get those guns off the street and do so to not violate the United States Constitution? It's a very, very interesting problem. I spoke a lot about the NYPD's use of stop and frisk tactics in 2013. What came to a head through a federal judge was that New York City conducts tens of thousands stops and frisks a year up to that point. This was under Mayor Bloomberg. And the numbers supported that it disproportionately affected minorities, African Americans, and Hispanics. And as a result of that, the federal judge said, hey, they're targeting a racial group of individuals. And this was the basis that de Blasio, coming into office as mayor, said, we're not longer going to do it. Now, some people criticized that decision because the violent crime increased then. So, sometimes it goes hand in hand with violent crime. Mapp versus Ohio. This is a search and seizure case. 1961 U.S. Supreme Court. This said that evidence found in the midst of an unreasonable search and seizure may not be used in criminal prosecution in state courts. So Mapp provides the basis of something which is known as the exclusionary rule. And this is important. What this says is this: if the police act unreasonably, without a warrant, and they find evidence, a murder weapon, drugs, stolen property, whatever it may be, they're not going to be able to use it. So the exclusionary rule keeps that evidence out from the jury to punish the police, to tell the police what they did in the past is wrong, and we will not tolerate this moving forward. So it excludes good evidence. 1984 U.S. versus Leone. The need for a good faith exception to the exclusionary rule. Federal courts in some jurisdictions say, as long as the police acted in good faith, we'll let the evidence come in. Other states give more protection, like New Jersey. New Jersey says, No good faith exception. If the cops made a mistake, they made a mistake. Doesn't matter if they were acting in good faith or bad faith. The exclusionary rule is going to apply. Inevitable discovery. If the police would have inevitably discovered the evidence, this is enough to allow that evidence to be admitted. So here, police with or without a warrant would have discovered the evidence, therefore it is admissible. The exclusionary rule would not apply. One of the oldest doctrines going back now 110 years is something known as fruit of the poisonous tree. It's amazing that we have a separation of church and state, but yet a lot of times the Supreme Court rulings have language that comes right out of the Bible, Old Testament and New Testament. This doctrine says any evidence obtained during a legal search would be disallowed at trial. This modified MAP decision and now allowed for an inevitable discovery rule and a good faith exception in states that find it. Seizures. The Fourth Amendment protects against unreasonable. That's the key to the Constitution. That term, it's not defined. What does it mean for it to be unreasonable? Right? So it could be a case by case basis. It could change over time. Right? When they were doing the United States Constitution in 1789, they weren't envisioning TikTok and the app and whether or not the app is spying on people through their algorithms, all these technological issues. Really, really interesting stuff. So, unreasonable searches and seizures of either person or property. Privacy. Citizens are afforded a reasonable expectation to privacy in their homes and in certain public places. Katz decision in 67. Searches are anything that violate privacy. In California versus Greenwood, one of my favorite decisions, it says, search warrant is needed if the police are searching trash. Well, guess what New Jersey does? New Jersey decided, because we as a state can give more protection, we have to give the minimum that the feds give, but we can give more protection than that. New Jersey decides that if you want to search the trash, you need a search warrant, believe it or not. That decision is a very controversial one, but it's one that stands for this idea that if the cops want to get into your trash and take a look what's in there, they need a search warrant. Technology changes every day. So law enforcement tactics made the ability to monitor activities and behavior easier. Should they be allowed to use drones? Should they be able to fly a drone up in an apartment building? Should they be able to focus the drone into the windows to see if somebody's packaging heroin? Well, isn't that a private area? Would they see things maybe that are meant to be private? And so this is an interesting dilemma for us to now deal with by way of the Constitution. You look at some of the technology, telephone, two-way radio in the car, revolutionized policing. These current technologies that help law enforcement agencies, record management systems, AFIS, the automated fingerprint identification system. Instead of rolling people with ink, they put your hand on it looks like a big photocopy machine, and it takes your fingerprints and palm prints and instantly uploads them. Less than lethal force technology, gunshot location technology, many, many more. Body cameras, very, very popular, required just about in every state now. Expensive. Where do you keep all that footage? Well, you have to keep it to protect people's rights. Surveillance, this is where the drones come in. High-powered telescopes, other things. License plate readers, all of these things are critical when it comes to the amount of technology that is out there. So this is essential to criminal investigations may be conducted through computers, satellites, mobile phones. This allows federal agencies to more easily monitor phone calls and internet messages. Currently, courts are still struggling over the question of monitoring cell phones and whether or not a warrant is needed in a non-emergency situations. GPS tracking is something that is very, very important. U.S. Supreme Court has just to hear cases dealing with cell phones in 2012. They ruled that a search warrant was needed to install a GPS tracking device on private property. And the reason why is that car that has the GPS tracking device that was installed by law enforcement is going to park inside of a garage. inside someone's home. So in essence, they're searching without a warrant inside the home. So 2012, that changed a lot for the feds. Now, we had been doing that, applying for search warrants, a form of a search warrant in New Jersey, which is known as a communication data warrant, for a very long period of time. Kylo versus United States in 2001, the use of thermal imaging requires a warrant. Why? They're shooting technology through a house. A lot of times they're scanning, looking for light use or heat. This would be very common in large grow operations with marijuana. Now marijuana is legal in so many states, but still not with the federal government. So very, very interesting to see how this develops moving forward. Canine searches using dogs, right? Their ability to smell is just so much greater than that of human beings, and they're so helpful. I used to love working with the dogs. Some of them are scary, I'm going to tell you the truth, but most of them are really nice, and they're there. And with cadaver dogs, bomb dogs, drug dogs, tracking dogs, whatever it may be. So in most cases, the court has determined that canine sniffs are allowed under the Fourth Amendment because it's the odor that's emanating that they're picking up. They're not searching anything. It's released into the air. 2013, the Supreme Court decision limited the use of dog sniffs outside the home for illegal drugs. So, that the Supreme Court signaling, well, now the odor is coming from the home. We might not be as comfortable allowing that, moving forward. So it is interesting to see how the technology has impacted that. The requirements for a warrant and serving warrants. The Fourth Amendment says that before police can conduct a search, with only limited exceptions, they must obtain a warrant. What's known as a favor for the warrant. Courts want the warrants. The key to obtaining a warrant is probable cause. Most search warrants are executed during the day and require the police to identify themselves. Knock and announce warrants are commonly used. They gotta knock on the door and announce themselves. Knock, knock, knock. Police, we have a search warrant. Please let us in. The ones that are dangerous, the Breonna Taylor tragedy, much of it was caused as a result of a no-knock warrant, where they're not knocking, they're not announcing, they're just knocking the door off of the hinges with a battering ram. Well, think about the horror that's inside there for that family. Now, sometimes police are justified, especially if the person has a gun or is dangerous. But no-knock warrants allow officers to enter the house forcibly without identifying themselves as police officers. Exceptions. These are when the police will not need a warrant. So the law recognizes that there will be certain situations where it's impractical for police to go get a warrant. Because of those circumstances, the delay in obtaining the warrant could mean that the evidence would be gone. So one of the exceptions is consent, where the party says, you know what, I'm going to let you search. This happens a lot on the side of a road. When somebody gets pulled over and the cop is rattling off a million and one things and they say, you mind if I take a look in the car? What they're really saying is, I would like to search your vehicle. Do you consent to it? You don't have to. You can say no. Plain view. Officers are permitted. If they see something in plain view, they seize illegal materials or evidence without a warrant. They're in the house legitimately responding to a call and there's cocaine, they can seize it and potentially charge the homeowner. Exigent circumstances. These are emergency situations, very narrowly defined, because what they don't want the court here is every time the cops go into a house, they say, well, we did so because it was an emergency. They're really going to scrutinize what that emergency was. An escape of an individual, harm to the officers or others, and the destruction of evidence. It has to be very, very narrow. Incident to an unlawful arrest. Somebody's placed lawfully under arrest. Well, the police have a right to search them. Why? For their security, for the security of everybody at the jail. You're not going to arrest somebody and put them in jail and they've got a 38 caliber handgun on their ankle. They're going to shoot a guard. They're going to shoot an inmate. They may shoot themselves. Right? So a very limited search of a person after that individual has been lawfully arrested. Automobiles are easily movable. So that's going to impact the time in seeking a warrant, right? Should police have probable cause to believe the vehicle contains contraband, fruits of crime, evidence, or instrumentalities of a crime, the vehicle can be searched. A lot of times, cops just use the fact that it is a vehicle as a reason to get into that vehicle, and that's where it gets a little dicey. Suspicionless search based on a place and reasonable potential for wrongdoing that can be abused very easily. The emergency doctrine, the danger of destruction of evidence is imminent. A lot of times they talk about, like smoke coming out from underneath the door. It's an emergency. Yeah, the police got to get in there, but if they wait for a warrant, somebody could be dead in there. So it's getting in there. Regulatory searches. Here, government officials such as health inspectors, vehicle crossing borders, airport screening, and fire inspectors, they're all required by law. Now, border's controversial, right? You have some people saying it's easier to cross the border now in the United States than it is to get through an airport and TSA checkpoint. To go through screening. It takes you a couple hours if you got a flight out of LaGuardia or JFK, right? It's a packed airport. So, there is this controversy, and I think we're gonna hear plenty of it during the election season for sure. Arrest. Someone is under arrest when a reasonable person believes he or she is not free to leave. Sometimes it's easy. Police officer says you're under arrest. Sometimes it's pretty easy. Handcuffs go on. But what about, being approached on the side of the street? Are you really free to leave? You may not physically be in custody, but you're in the custody of the police in their presence. Courts are still unclear if the words you are under arrest are necessary and sufficient. A lawful arrest entails taking a person into legal custody, either under a valid warrant or based on probable cause the person had committed the crime. We all know the Miranda warnings, right? We hear about it all the time. We learn about them at a very young age. Here in 1966, Miranda versus Arizona, the establishment of guidelines that must be followed when informing a suspect of his or her rights. But there's exceptions to that. One of them talks about the community caretaking exception, the case out of New York, where it involved a gun near a school. And the officer, finds the suspect, doesn't have the gun, and says to the suspect, "Where'd you throw the gun?" As he's under arrest. Doesn't warn him about Miranda. And the guy says, "Over there, I threw it in the alley." And they go and get the gun and charge the guy with it. Well, the court said, even though that person didn't receive his Miranda warnings, there was this responsibility that the police had to make sure that that gun didn't get into the hands of children. So that became the critical issue. The right to counsel, the third degree in the 1930s, a very common practice where people were badgered until they confessed. The Sixth Amendment guarantees the right to counsel during questioning. Escobedo versus Illinois in 1964 ruled that his Sixth Amendment right to counsel was violated by the police when he was refused access to an attorney. So if they want to see a lawyer, police have to facilitate it. So these are the procedures, the safeguards that are set up by the courts to say, hey, police, even though we have this Constitution, we're not going to let you figure it all out. We're going to tell you what a lot of this means, because if you don't follow it, chances are that evidence will be excluded at trial. The exclusionary rule will keep that evidence out.